We are a team of techno-legal professionals who deal with the challenges faced by the construction industry. Today's topic: Termination of Contract. We have already spoken a lot about a contract and its various components, including change in scope, etc. And now let me throw some light on the termination of a contract and various aspects related to this critical matter. Termination is one of the most fearful words, be it in the context of any aspect of our life or any agreement. It is almost rare that termination does not leave behind a scar. In construction law, particularly, the process of termination requires to be handled delicately and its consequences need to be understood clearly. It is a double-edged sword, wherein contractor also gets hurt to a large extent. Be a process of termination in modern contracts, there could be rare conditions precedent to termination. However, the procedural formalities need to be performed as and by way of fairness and good faith. Non-compliance of formalities may put the government, authority, or the contractor in bad light before adjudication forum. There is no legal requirement to observe the rules of natural justice in terminating the contract except that the party terminating must faithfully follow the procedure if laid down in contract. Termination bad in law: any termination of contract violating the terms of contract or against the provision of substantive law or public policy could be considered as termination bad in law. This shall deprive the terminating agency any protection or privilege arising out of law and should be faithfully avoided. See a right to payments on termination for the works executed but not paid remains unaffected, under the principle that nothing can be et gratis. In context of right of liquidated damages, the provision is strictly by way of measure of compensation for delay caused in completion of contract. The word completion loses its teeth on termination by government authority if government chooses to terminate. Hence, the clause is rendered ineffective. The government authority who otherwise could have been entitled to LD becomes liable to unliquidated damages under common law of consequences for the breach of contract. A free will to enter into a contract. However, once you enter into a contract, you are the prisoner of the contract. To come out or to terminate the contract, one is a slave to the terms and conditions of the contract. The provision in law and the terms of contract shall govern the adjudication of consequences of the termination of contract. Ways of termination of contract. There are four major ways in which a contract gets terminated excluding completion of contract, and those are: impossibility of performance, frustration, breach of condition of contract, foreclosure, rescission. For interests in contracts, all contracts are entered into to have three principal interests. Interest of expectation. While entering into a contract, a party has interest to expect reasonable gain. Government authority gets the project envisaged and contractor expects profit. If contractor abandons the project/job, government authority earns the right to get executed at the risk and cost of the contractor. As per trade practice, contractor reasonably expects 10% to 15% of cost as legitimated profit. In the event of unlawful termination, the contractor expects and is compensated 10% to 15% of profit out of balance work he is deprived of. 2. Interest of reliance, placing reliance on promise made by government authority. The contractor, on getting a contract, starts investing on following functions or heads, and therefore, the losses for the contractor include: mobilization of resources, providing necessary infrastructure and enabling works, financing arrangements, contracts with vendors/subcontractors. 3. Interest of restitution. In all cases, the contractor earns the right and entitlement to terminate the contract. He gets the right to restitution resulting from reliance he placed on government authority for good faith and diligence. Types of termination. The termination of contract, unless frustrated, is of two types. Termination for convenience. Termination for convenience is also known as no-default termination. It allows a party at any time for its convenience to terminate contract by a notice with or without indication of a particular clause in the contract. The contractor will have the right to receive the cost incurred up to termination and recover the damages resulting from such termination. There is a growing trend of termination for the convenience by government authority. If this is envisaged, fair compensation needs to be paid. Modern construction contracts provide for a clause for termination. The clause of failures due to government authority, as enumerated in contract, may be a. Failure to provide adequate work front/row/site. B. Failure to make timely payments. C. Failure to correct situation of suspension of work within reasonable period, say 3 months. D. Contractual obligations. In case of frustration or any other reason, parties may desire to foreclose or annul a contract. They may do so on terms they may agree upon. 2. Second type of termination is termination for default. In performance of the contract, either of the parties find that the other party is not reciprocating its obligation or unilaterally is in default of its own obligations. In such an event, the party perceiving the fault of the other may terminate the contract, serving the notice to suspend all further performance and come forward for final settlement, either on amicable terms, or may lead to disputes to be adjudicated as per contract/law. The alternative in such a case may be to extend time for performance either with or without the intention to recover pre-decided damages. H. Default for the termination. Before the default is decided, it is important to consider following facts. The terms of contract as provided in the termination clause. The circumstances leading to shortfall/backlog of performance. Defaulter's explanation for the defaults. Weightage of timely performance. Consequences of such termination. In any event, a contract should not be terminated if there are chances of default to be considered as excusable clauses like acts of God or circumstances beyond the control of the contractor, etc. I. Termination notice. Wherever the notice of termination is required to be served as per contract, it is mandatory to serve the notice to the authorized agency, providing a cure period to improve the performance, failing which there could be an automatic termination. The notice must include briefly narrated events of defaults, which has prompted the issue of termination notice. In construction contracts, one or the other parties may often lose patience with time and/or money being invested. If time is the cause, most often the government authority desires to replace the agency, expecting acceleration in performance and opts to terminate the contract. In such a case, the government authority can terminate because of fault of the contractor on various grounds. J. Duress, from purely whimsical act to termination without any legal ground to circumstances of duress. There are a number of grounds for termination, and they could be many, not limited to the following. Defaults in contracts. Lack of resources to cope up with agreed program. Object of contract is lost. No skill to perform work to required workmanship and specification. Lack of willingness to abide by instructions of engineer in charge/government authority. Inability to make up loss of time. No will and resource to amend breach of terms of contract. Breach of terms of contract, time at large. K. Fundamental breach is, which destroys the possibility of further performance, and it may frustrate commercial purpose and parties or party may see no sense in performing the contract. In techno-legal parlance, the modern test of fundamental breach or frustration is: does the occurrence of event deprive the party of substantial benefit which was intended as consideration for performances? In construction law, the phrase material breach is same as fundamental breach, making further performance against interest of the party. Right to terminate is usually provided for repudiatory breach, whereby a party wants to only demonstrate his decision not to discharge his contractual obligations. L. Consequences of illegal termination, as in when a party illegally terminates a contract, the aggrieved party is entitled to compensation under Section 73 of Indian Contract Act. In construction, damage naturally arising out of breach, illegal termination, are as below. Damages for contractor. A. Profit on balance work due to harm to interest of expectation. B. Untimely demobilization of resources. C. Partial utilization of infrastructure created. D. Consequences of failure of vendor's contract. E. Loss due to distress sale of balance of material at site. F. Compensatory retrenchment cost for resources hired and employed to complete the works. It is important to note here that a party illegally terminating a contract has no right to have counterclaims. Conclusion: termination should be the last option for government, authority, and contractor. Experience has shown that the party which has terminated the contract as a soft solution to contract administration has not favored a repeat experiment of termination. Admittedly, even at a high price, termination is the last and only resort. In the following videos, we will elaborate more details on aspects of contract administration. For more details, please visit our website Dariani's Engineers and Associates Private Ltd.